Thank you for listening to Ingram Law. We always appreciate you being a guest. Our website is joeingramlaw.com. My phone number is 205-335-2640. Our podcast is Real Law Alabama, where we discuss divorce topics, criminal law topics. Sometimes we discuss issues off topic that are relevant to the community at large. Sometimes we have featured guests. But tonight, we're going to talk about something that I deal with routinely, almost every week in my criminal practice. And I had one this week that really bothered me. And I thought, this is something I'm very passionate about. I want to talk about this week. Because there's a great misconception in the community. There's a great misconception by some judges as to what a reasonable bond should be for a criminal charge in Alabama. Now, you can get charged in a municipality for DUI, harassing communications, domestic violence, possession of marijuana. Second, usually in municipal court, if you're a first-time offender, DUI, marijuana second, domestic violence, harassing communications, your bond is probably going to be $1,000. Sometimes you may get lucky and get released on your own recognizance, meaning you sign your name, you agree to show up for court. That's municipal court. Let's say you get charged with a felony, and we've talked about the difference between misdemeanors and felonies. Felonies are crimes in the state of Alabama where you're going to be punished up to a year and a day for a Class C felony, not less than 10 years. And so you would be charged in state court. And let's say you get arrested, you make a phone call, you call a family member, they call me, and they say, Mr. Ingram, will you go represent my husband, my son, nephew, spouse? They are charged with this crime, and they have set their bond at, well, I'll just use an example of a case that I have right now that I'm very passionate about and really outraged. I have a client that's charged with a Class A felony, which in the state of Alabama, if he is found guilty, the minimum sentence is 10 years, not more than life in prison for a Class A felony. Now, this is not capital murder. Let me just go ahead and clear the room. If you are charged with capital murder in Alabama, there is no bond allowed. You're just going to sit in jail to the trial. That's just it, folks. I'm not talking about a murder. Murder can be up to $1 million bond. Okay? We're not talking about murder. We're talking about a Class A felony. We're talking about a sex offense. It doesn't have a lot of popularity with the community standards at large, but it is just that. It's an allegation. It is a charge. The last time I checked, my client is presumed innocent until he is found guilty by a jury of his peers, or he decides to enter a guilty plea to that charge. The presumption of innocence follows him. My client was arrested with a sex offense in a county in Alabama. They charged him with $1 million bond. $1 million. Um, we have a bond hearing. Um, courts look at lots of things. How long have they been a resident of the state of Alabama? Do they have significant ties to the community? Are they a danger to the community? Are they a flight risk? Are they gainfully employed? Do they have any criminal history? These are all things the court should consider. This particular case, my client was maybe 30 years of age, been a resident of Alabama for 20, 25 years, no criminal record, gainfully employed, good job, not a flight risk, had family here, had significant ties to the community. They considered the charge itself a danger to the community. Well, maybe. He had no prior criminal history. As a criminal law practitioner, that bond for a Class A felony should have been somewhere between no more than $60,000 for a Class A felony. Class B felonies in the state of Alabama are usually between $5,000 to $30,000. For a Class C felony, the bond range is $2,500 up to $15,000. Now, for drug cases, and I handle a lot of drug manufacturing and trafficking cases. Drug trafficking in Alabama is a Class A felony. The bond range is $5,000 up to $1.5 million. I can understand if you're arrested with kilos of marijuana, kilos of cocaine, methamphetamine, large quantity of schedule controlled substances such as pills, Xanax, Klonopin, Adderall. List goes on and on and on. So drug bond cases can be set pretty high and significantly in the state of Alabama. But the judge didn't go along with my argument. The DA got up there and said, "Judge, he is not a United States citizen of the United States, and we think he's a flight risk, and he is a danger to the community. Bond shall remain the same." Denied. Do I think it's fair? No. Do I agree with it? No. Do I respect the court? Absolutely. I do not wear the black robe. I do not sit on the podium. I do not sit in judgment over anyone, nor do I want to ever. That is not my role. We do the best we can with what we have to work with. We move forward. Just in case you are following along and you're curious, well, Joe, what if I'm charged with DUI in Alabama? The bond is usually no more than 1,000. It can be up to 7,500. That's usually if it's a second or third DUI, and they're able to prove it when they charge you and arrest you. Most traffic tickets, when you sign the ticket by the state trooper or the police officer digitally, you're actually signing a bond. Your signature is you're signing your name on your own recognizance that you will either show up and defend the case or you will plead guilty and pay the traffic ticket before court. So that's the significance of signing for the traffic ticket. So that talks a little bit about bond schedule in Alabama. Now let's talk about this. Let's say, I represent you. I get your bond. Let's say you have a $30,000 bond. Let's say that you have family in Jefferson County and they own property. I mean, real property, real estate. If you have the equity in your home, someone in your family, they can post your bond with real property. It's sort of like posting collateral. As long as you show up when the case is over, the bond is removed from the real property. I always hope that my clients are able to use real property to post a bond. Sometimes that is not an option. And in those cases, to get out of jail, sometimes you have to use a bail bondsman. There is a market for them. They are a needed entity in Alabama and in most states. And so you go to a bail bondsman. And not speaking for any bail bondsman personally, but if your bond is $30,000, typically you have to put up 10%. So you would pay $3,000 to be released from custody and you get out of jail. Do you get the money back? No. That is the downside of using a bail bondsman. You are literally throwing money away to get out of jail. Sometimes that is our only way, our only resource to get you out of jail. We accept that. We live with it. We get you out. We move on. So that covers the bail schedule, bond, how to bond you out in state court. Let's talk a little bit about federal court. Federal court is so much cleaner and sterile to some degree. Usually, if you are a first-time offender in federal court, usually, unless there are significant allegations or specific charges like computer crimes, sex crimes, maybe aggravated identity theft. Certain crimes, they can impose special circumstances tied to your bond. But let's just start out You're charged in federal court, you get indicted, you hire an attorney to represent you. Most times you're going to go to court, you're going to give the probation office some information. There's nothing in there that is attorney-client privilege. It's just for the probation office to use to recommend to the federal magistrate judge what your bond amount should be. They'll run a background check on you. They may check your references. They may check your work history. They may check to see if you have a drug issue. You may have to be drug tested while you're out on bond. But typically bonds are set at, $5,000, sometimes $10,000. I've seen a $50,000 signature bond. And that's typically how you get a bond in federal court. Sometimes, if you are considered a flight risk, the court may ask that you be put on an ankle bracelet. And that requires, wherever you live, to have a home phone landline. Nobody has that anymore. I have clients all the time, and I'll say, well, I can get you out. The probation office is recommending you be on an ankle bracelet so they can monitor you where you are. You're going to have to go install a home phone line. What? Nobody has a home phone anymore. Well, you do now. Sometimes, in some special circumstances, the court may require, the probation office may require, the U.S. Attorney's Office may even have a recommendation. Judge, if we're going to let this person out on bond, we want them to have a third-party custodian. Third-party custodian. Joe, what does that mean? Well, it's real simple. You have to bring somebody to court. They have to sign a document in court in front of a federal judge that reads and says, I, Jane Doe, John Doe, agree to be the custodian of my relative. And I will be responsible for him. I will make sure he comes back to court. I will make sure he shows up for drug testing. If I find out he is going to flee the jurisdiction, meaning run, abscond, take off, I will inform the court. That is your duty that you pledge to the court, because the judge is going to ask you those questions. Are you willing to sign up for this? Are you willing to be responsible for this person? They're going to live with you. You're going to make sure they work. You're going to make sure they're drug tested. If they run, you're going to notify the probation office or the U.S. Marshal's office. Do you also understand that if they take off and we find out that you helped plan their escape, we will take you into custody until we find that person? Had that happen one time. Also had the situation where it was explained to a family member, and we stood out in the hall, and the family member said, not really sure I want to be the custodian for my family member. I love this person. Don't want to see him sit in jail, but I don't know that I want that responsibility. Understand, agreed, noted. It's a lot of responsibility. Also had the occasion one time where I had the third-party custodian call me, and they said, Joe, I'm going to go to the court Monday, and I'm going to tell the judge I want to be relieved as the custodian for my family member based on circumstances. I understand, agreed, noted. Give me 48 hours to try to find another body. Sometimes you can, sometimes you can't. Sometimes you can work out an agreement with the U.S. Attorney or the probation office. Depends on the charges, facts, circumstances, nature of the crime, nature of the person, criminal history. All those things matter. So that's a little bit about getting out on bond in federal court. So, if you are just a regular citizen out there and you've never had to need the services of a criminal lawyer, and you read the paper, you read the news online, I can understand how you feel about crimes. I can understand when you say, they're guilty, they shouldn't get out of jail. Well, you'll look at life a little differently if you have a family member charged with a crime. You will want that presumption of innocence to follow them throughout the case. You will want them to get out on bond unless they're charged with a capital offense or they are a danger to the community at large. So that's just my take. As always, this is Ingram Law, LLC, Real Law, Alabama. We talk about divorce, family law, criminal law topics. You can reach us at joeingramlaw.com. Our phone number is 205-335-2640. As we always say, take care of yourself and each other and have a good night.
No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.